As you may or may not know, you are in the Canton High School auditorium. And we welcome you here to the Canton League of Women Voters Candidates Forum. And tonight we are very fortunate to have 3 different races represented. We have the regional probate judges who are already seated on the stage. We have the 17th district representatives and the 8th district senate race being represented. Unfortunately, Leslie Hill is unable to make it this evening. She is with a terminally ill family member, so please keep her in mind in your thoughts. She has a written statement that she will be having read tonight, so you will be able to hear from her, if not in person, at least by her written words. Tonight, if you hear of your friends or family that were not able to join you live tonight in this auditorium, this broadcast is being videotaped, and it will be played both on Nutmeg TV and it will be available via YouTube on the Canton League of Women Voters website. So those times will be posted, and if you weren't able to come, or you know someone that wasn't able to come but is interested in hearing the candidates' views on the issues, please encourage them to watch one of the airings. This forum is brought to you by the League of Women Voters of Canton. Our primary purpose is to engage and educate voters. And we welcome you all to please be good listeners and to please be respectful of all of the people that have done a lot of work putting on this event. And please show an example to all of our student volunteers who are here. The student volunteers are over here. Raise your hand if you're a student volunteer. The student volunteers, they will be circulating throughout the evening with pencils and note cards if you would like to write your questions down, and then they will be bringing them forward to the question reviewers and then up to the moderator. So if you have a question, just raise your hand, they'll give you a card. If you're done writing out your question, just raise your hand again, and one of them will be by to pick up the note card from you. This evening's moderator is Meg Gaines, and again, I please ask you to be respectful to those sitting around you, that everyone is here to listen, and someone once told me there is a reason why we have one mouth and 2 ears, and we should use them accordingly. Thank you all for coming.
So now it's my turn. I'm Meg Gaines, moderator for tonight. I will reiterate, we ask that you withhold applause or comments or displays of approval or disapproval until the end of each section. The format for tonight, first the probate judges, candidates, each will get 2 minutes to answer a question. They will each get the same question, going back and forth, and they can have up to 2 minutes to answer. They also can talk back and forth. After that, you have a 5-minute time, a time bank. So the timers will be timing, and you'll use it up as you go back and forth. Do you understand what I'm talking about? You know what I mean? You can say no. You can try again. But topic A, the other candidate speaks, and you're like, I have something I want to say about that. You can talk additionally. You can have some more time. Okay? Okay. I know this is your first time for both of you. It'll all work out. It'll be good. Okay. So we will start. First of all, our candidates are the current probate judge, Cynthia Becker, and I know it goes against the grain. And the other candidate is Charles Chip Houlihan. Okay. And now we're going to the clapping until the end, okay? Okay. First question goes to Ms. Becker. What is your opinion of the outcome of the 2011 reorganization of the probate system that created a regional probate court for the Farmington Valley towns?
Well, that's a great question. When they first started talking about consolidation, I was not in favor of it because I was concerned that the residents in the towns were going to lose services. They were going to have to travel a great distance. Many of our users were elderly or disabled. So they would be at a disadvantage having to travel a great distance, and the courts were at that time able to sustain themselves with the fees. However, I'm very, very pleased to state that my fears were not realized, that the regionalization of the courts has been a great success. Other than the fact that people have to travel a little bit further, we've been able to get around that because I go to people. So if a person who's the subject of a proceeding is not able to come to the courts, I go to them. I travel to nursing homes, hospitals, psychiatric institutions. I've had hearings at people's kitchen tables so that they have an opportunity to participate. So from that perspective, my fears did not come to bear, and I believe that we have fiscally been very, the regionalization has been very beneficial. We've been able to save some money. We have one court now housed under one roof instead of 4 separate courts housed under 4 roofs. So it really has been a tremendous thing. The staff has come together under my leadership. I've been able to consolidate the staff from 4 courts, the files from 4 courts, and all our furniture, you name it. We pulled it all together. We've merged the 4 courts very successfully, and I'm very pleased and proud that under my leadership, the Simsbury Regional Court is a huge success and one of the best courts in the state. We are reviewed every 2 years by the Probate Court Administrator's Office, and our reviews have always been, we've exceeded their expectations in our timeliness in setting hearings, in the management of our files, in our budgeting. We always return money. So my time is now up, but again, thank you for the question. I'm very happy to boast that it's been a great success.
Thank you.
Okay, we have a problem. I asked you to make sure everybody's cell phones. I'm recording this with mics, so if your cell phones come off, then I cannot hear what's being said on stage. So you need to turn your cell phones off. This is only fair because this is going to go on TV, okay?
And I did not talk about the timers. Do you see where they are and so forth, how it works? Okay. Mr. Houlihan.
The 2011 reforms were really a needed step to bring Connecticut probate courts into the 21st century. There are 169 towns in the state of Connecticut. Each one had their own probate court. They did not require the judges to be lawyers. You had very strange things. I had an enormous case out of Washington Depot, where a person had been conserved for being an alcoholic, and he dried out after 3 years. But the conservatorship lasted an extra 12. There were abuses in the system. The system needed to be reorganized and be made efficient. And the 169 towns have turned into, I believe, 52 regional probate courts now. It's the kind of system that is it is a cost saver for the taxpayer, and it guarantees a level of professionalism, both among staff and, of course, among the judges as well, who now must be lawyers. The system did not work well under the old system, and it was insightful to decide that it needed reform, reorganization, and it has achieved much greater efficiencies. The system has worked well. The court has improved substantially. The finances, instead of having 169 different people administering the funds in the probate system, the state of Connecticut does it now with the treasurer. It's a focused point of accountability, and as a result, we can have greater confidence in our probate system. So I judge the 2011 revisions to be a success.
Thank you. Either of you have anything further? Okay, this question goes to Mr. Houlihan. What is the probate judge's role in dealing with persons with intellectual disabilities?
The probate judge has a very sensitive role in dealing with people with intellectual disabilities. And underlying it all is a degree of respect that you accord the person. It's fairly clear, and in some of my own personal experience dealing with people with dementia, that you have varying abilities. And intellectual disabilities, you're going to have strength and you're going to have weaknesses. And underlying all of it, you have to respect the person who comes before you. You have to see where they can participate in decisions, judgments, and implementation. And you have to determine when the decision needs to be made for them. But underlying all of that, you need to make sure that they are cared for in the least restricted method, giving honor and respect to their abilities as a human being. And it's with that respect that you need to accord everybody that comes to the probate court, whether intellectually disabled or not.
Thank you. Ms. Becker?
Repeat the question, please.
Yes. What is the probate judge's role in dealing with persons with intellectual disabilities?
The probate judge's role is presiding over a procedure called the appointment of a guardian for a person who's intellectually disabled. So when a intellectually disabled person becomes of majority, the age of 18, and they in most cases still require the assistance of, in the past, usually their parents or a family member. As most people know, as an adult, the law views you as able to handle your own affairs. So in order for a family member who's always helped the intellectually disabled individual or a loved one who's helped them to continue to help them, to have access to their medical records or their financial records, to enroll them in schooling or activities, to assist them with medical appointments, the court has a procedure that is called the appointment of a guardian of the intellectually disabled. There are two kinds of guardianships. There's the plenary and there's the limited. In a plenary guardianship, the person who is the subject of the proceeding, called the respondent, is completely unable to perform various activities that are assessed by the Department of Developmental Services. The Department of Developmental Services will always provide a report, an assessment when an application's been filed, and they will opine whether the person is able to assist themselves regarding deciding where they're going to live, release of clinical information, educational programs that they like to engage in, and all other areas to help them maintain a degree of independence. If they're able to do some of those areas, then we appoint a limited guardian, and whatever authority the guardian is not given, the person retains. So in sum, as I'm running out of time, the probate court assists these individuals by appointing guardians who can legally continue to assist them in achieving the greatest amount of independence and also protecting them.
Thank you. Do either of you have anything further on that particular question? Okay. The next question goes to Ms. Becker first. Nationally, some probate judges are denying gender marker and name changes to LGBTQ individuals. Has this been an issue in Connecticut? And what is your perspective on probate courts and LGBTQ people?
Well, probate courts are statutory courts. The judges are bound to follow the statutes. So opinion or preference does not come into consideration in these cases for the judge. If the law allows it and provides for it, then the judge is to follow the law. Legislators make the laws, the judges enact them. As far as name changes go, there are very few requirements in order to approve a name change. The petition cannot be on the basis of fraud. If it's a minor, the parent will apply on behalf of the person. But there are very few requirements when one wants to change their name, and certainly LGBT would not be a reason to disqualify someone for a name change. Again, if If it's a minor child and for some reason a name change is not in their best interests, we go ahead and we evaluate that if LGBT was part of the mix. But again, there's no consideration on the part of the judge. As far as gender marker goes, the Superior Court has jurisdiction over the change of gender markers for people who were born in Connecticut. The probate court only has jurisdiction over the change of gender markers for folks that were not born in Connecticut. And again, there are certain statutory requirements that have to be met in order for a judge to grant that. If the judge grants it because the statutory requirements have been proven to the court, then the judge's decree is sent to the state where the person was born. And what we're hearing is that some of the states are not recognizing our decree. We don't have any control over that. But again, the statute's very clear, the requirements that have to be met and the things that have to be proved to the court in order for the judge to grant the petition.
Thank you. Mr. Houlihan.
I have not heard of any cases that come up raising that issue specifically in the probate courts. And I have some difficulty seeing how that would be. Our court system, I think, treats people fairly and equally and respects the choices that are made and the issues that are presented. So I've not heard of anyone being rejected, and frankly, I would be surprised to hear that. I think the court system is open, it's non-discriminatory, and there just haven't been those situations. I think we're fortunate. There can be issues in other courts. If they reject our court orders, it raises constitutional questions and puts a burden on people to enforce them under the full faith and credit clause of the Constitution. But for Connecticut, I don't see that as being a difficult situation, and certainly I think the courts have been fair, even-handed, and non-discriminatory in their dealings.
Thank you. Yes.
One comment. I just want to be clear that the probate courts do not get involved in constitutional issues, though. We are a statutory court. The Connecticut legislature passes laws, and we enact them, and we do not have jurisdiction over constitutional issues.
And I was simply making the comment that if courts in other jurisdictions are refusing to recognize the decisions of Connecticut courts, that implicates the Constitution and implicates the full faith and credit clause. Our decisions are to be respected there as their decisions are to be respected in Connecticut.
Thank you. Okay, the next question goes to Mr. Houlihan. What defines a successful case? Do you track outcome measures such as the number of cases or customer satisfaction or something else? Or
usually courts do not have a follow-up, although in Superior Court, occasionally jurors will get follow-up questions, and occasionally the parties will want to know how the judges have performed and how the different parties have performed during the course of the trial. I've not seen that in the probate court system. I've never received a questionnaire. The mark is that you try to do no harm. Most cases go through fairly uneventfully, but there are cases where there are problems in the family, dysfunction in the family, that comes out in probate court. And even if the issue that is at hand is relatively straightforward, oftentimes you see old resentments, you see past behaviors coming out and creating a great deal of conflict that needs to get managed, that needs to get resolved, and needs to be addressed head on. You can't ignore those issues. You need to listen, you need to be open, you need to allow people to express themselves, even if it may not be particularly relevant. And then you need to decide. It is important to get to resolution in a probate court. It's important that you listen to the parties, and if there is no agreement, if there's no consensus, then you have to decide, because it's a service to everyone there to have the case move forward. The objective is to execute the will or to have the conservatorship and make sure that the person conserved is cared for in a proper manner. that is a successful outcome. Sometimes it takes a great deal of work, but it's that kind of decisive decision and conciliation that's required.
Thank you. What defines a successful case? And do you track outcome measures such as number of cases or customer satisfaction?
Well, I don't track the number of cases as the presiding judge in the court. However, the Office of the Probate Court Administrator requires us to, through the computerized system, obviously track the cases, the kinds of cases that we hear, and how many. And the 4 towns that participate in the probate court ask us each year to give them that information. Last year, we oversaw about 400 decisions estates, that includes the smaller estates, over 200 other matters, which would be conservatorships, guardianships of the intellectually disabled, the estate in person of minors, termination of parental rights. The conservatorships, we only had about 45 new cases last year, but they are ongoing, where decedents' estates tend to be wrapped up in a year or so. Conservatorships can go on for a long time and have many, many hearings. The way I perceive my success as a judge is by first off, the response from the public. I've been elected 5 times now to serve in this post, and nominated on my 6th time now to run for re-election. I've never been overturned on appeal. I don't have a law clerk like Superior Court judges do. I do all the legal research when I have evidentiary hearings or difficult legal factual matters before the court. Sometimes I can spend 10 or 15 hours on nights and weekends researching and drafting my memorandum of decision, which can go a page or 20 pages. And I've never been overturned on appeal, which to me is evidence that I've gotten it right, that people are happy and or they can live with the decision. And as my opponent alluded to, I think I try to get people to come to an agreement, because it's a lot easier to live with a decision if you've made it yourself than if someone else has imposed it upon you.
Thank you. Anything further on that question? Okay, next question goes first to Ms. Becker. Probate judges address a wide range of vital matters, from control of an individual's finances to his or her health care. What do you perceive as the greatest obstacle to justice and individuals' welfare that are handled in probate court? What policies might improve the outcomes?
Well, I think the areas that we struggle with the most in the probate court are usually drug, alcohol abuse, and also psychiatric disability. We just don't have the laws and procedures to really help people like I would like to help them in those areas. We can appoint a conservator for a person who's incapable of managing their affairs, who's an alcoholic, but the success rate is very low, because that conservator cannot force treatment on someone. They can only help them to seek treatment. And the rate of recidivism is so high that it is very frustrating that we're very limited in what we can do. You can appoint and you can have a special commitment for drug and alcohol disease, but again, if you can actually perform the commitment, which is difficult, a bed has to be available and it has to be certified as such, and there's many time frames. At the end of the day, once again, you cannot force the person to receive treatment. So we do, it is discouraging that we can't help people more in those areas, but it's not for lack of trying. So I do believe people receive justice in the probate court. We have a very informal physical layout. We're in a conference room. I don't wear a robe. I don't sit behind a bench. We sit around a conference table. We try and make people feel as comfortable as possible in the least intimidating environment. And I really feel it's important that everyone should have their day in court. They should be heard. They should be able to say what they want to say. And so I do give that a lot of effort, because again, as I indicated, I'll travel to where people are just to make sure that they feel that they've been heard and they're represented. And I do think that we do a good job of delivering justice.
Thank you. Mr. Houlihan.
The obstacles that you find in probate probate court are generally the same obstacles that you find before you get to probate court. The alcoholic who has lost control of his life, or the drug addict, treatment, the relapse, treatment again. It is all of those failures that end up coming to the probate court. And the question is, really, who's the quarterback for all of this? And the probate judge has some limited capacity in that regard, but it really involves being able to have a conservator or a family member who is able to start to access the resources, because that's outside the purview of the probate court. And so the frustrations that existed before the conservatorship commitment tend to follow on. What the probate court can do is add some order and some structure where it's needed, and the strength of a court order. But you still have the difficulties in the organization of the health services, the treatment services, the addiction services that are out there. How do you coordinate those and get those together? It falls onto the conservator, the person in charge of the commitment. And that, is a continuing frustration for all. And the probate court's responsibility is to try to add as much structure, to try to identify the resources that the responsible parties can go to try and make things occur better than they did before the court system became involved. These are oftentimes intractable, very difficult issues, but they're issues that need to get addressed, and the coordination function, I think, is just a continuing difficulty for the families, the courts, and the others who are involved in the services.
Thank you. Anything further on that? Okay. The last question, we'll go to Mr. Houlihan first. What ideas do you have to improve the work of the probate court?
I think one of the most important things to do is to greet people and introduce them to the system in a positive, friendly manner. I've had many clients come to me in tears because their frustration boils over when they're met with forms and so forth. We need to let people know that there is a human hand behind the procedures and the formalities of probate court. And that is a primary goal of trying to make it accessible. Try not to because everybody that comes there is in crisis of some sort. There's a parent or a relative who needs a conservator because they can't manage their affairs. They're in decline or they're in addiction. A person has just died and suddenly they're on their own and they're trying to find out what to do. It is difficult, that first approach. And eventually they're going to need to get to a lawyer. And they can't come to the probate judge to be their lawyer. But they can be welcomed. They can be told that the system is logical, that it has an end, that it has a process that will be fair and that they will be heard. It's important to provide them with confidence in the system. And if there are disagreements that need resolution, that you're going to be able to resolve those. I've tried many cases, and trying cases is a very humbling affair. And because you have to realize that other people have perspectives, different experiences, different appreciation of events. And so when you go to those hearings, they need to know that it's fair, they need to know that you're competent, and they need to know that you're going to render a fair decision. And that's what I would do as probate judge.
Thank you. Ms. Becker, yes. What ideas do you have to improve the work of the probate court?
Well, I think every system, every governmental agency, there's always areas to improve. Nothing is perfect. The probate courts have come a long way. Since we regionalized, we've worked hard to streamline a lot of our procedures so we don't have as many forms. It's not quite as intimidating for people. I think it's critical that the staff at the probate court be well trained. I am very fortunate and proud of the staff at my court. have trained them over the last 8 years, and they are compassionate, kind people. They're the first face of the probate court that people will see when they come in their time of crisis, and they need to feel confident that the people are willing to help them. My staff goes out to great lengths to assist people. There is something in Connecticut that we are looking at now that I think is going to be a good improvement for the probate court, and it's something called unsupervised probate. It's been implemented in Massachusetts and Texas, two very different places. But the theory is that there's some procedures in the probate court that are very cumbersome. They place burdens on people that are unnecessary. If your spouse dies and you're inheriting their entire estate, should you have to file a myriad of forms if it's just you and the creditors are paid? So this unsupervised probate is something that the probate court administrator has been looking at. I've gone to a seminar on it. We're becoming educated in that area. And it provides for the probate court to stand by and be there to resolve disputes if need be, but to not lord over people with forms and create burdens on people. I think it's great. I think it certainly merits looking into more, and I am encouraged that it will further improve the probate courts in Connecticut.
Thank you. Okay.
I also practice in Texas, and the unsupervised works well when things work well. And if it's a simple thing where it's husband to widow, it can't be beat, and it's much less cumbersome, less expensive than the Connecticut process. But it also means that they're unsupervised, and so now I have a case in Texas where you can't get information from the person who is unsupervised, and the person who's unsupervised wants to do this and wants to do that, and doesn't want to follow the will. So, you know, there is a happy medium, and for many estates, unsupervised estates would be beneficial, and sometimes you just have to have that supervision to make sure the assets are going where they need to go, that the bills are paid and the problems are solved.
So, and I agree, it's a system that you can opt in or out of, and again, the probate courts are very much involved in the process, but they take a role once the will has initially been admitted and the fiduciary has been appointed. They then stand by in the event of a dispute, so that a disgruntled creditor or a beneficiary who is unable to get information can still bring the matter before the probate court. So it would not be a mandatory procedure that you're required to participate in, and that creditors or beneficiaries would be shut out of. That's my understanding to date. We've just started to really investigate it in Connecticut, but I think it's certainly worth looking into. Anything that can improve the system, make it more user-friendly is a good thing for the people in Connecticut.
Thank you, Elsa. Okay, we will do our closing statements, and the first closing statement is Ms. Becker.
So thank you for coming tonight. I'm very grateful I've had this opportunity to address the folks in the Valley who are either watching or here tonight. And I have a saying that I'm fond of, that experience matters in the probate court. The probate judge is not just a figurehead. As you probably learned tonight, there's some pretty serious matters that come before the probate judges. They have decisions regarding who gets your property, who's going to parent your children, whether your civil liberties are going to be deprived by a conservator. Very important areas that the probate judge oversees, and there's a lot of power. I believe that a well-educated and experienced probate judge benefits the users of the court. This is my almost 19th, almost 20th year as a judge of probate. I've been re-elected 4 times. I've been elected 5, but re-elected 4. This is the 6th time. To me, it says that the people, the users of the court and the residents of the Valley are happy with my achievements at the court. I'm quite proud of the regional probate court. It's been a success. I have a vast amount of probate experience. Probate law has been the only area of law that I practice. I've committed my entire legal career to probate law and procedure. Prior to becoming the judge of probate in Avon 20 years ago, I was a staff attorney for the West Hartford Probate Court. I was also a private practitioner of probate law. So I have a wealth of knowledge and experience in the probate area, and I believe that it has benefited the people here in the Valley. I think that the regional probate court also speaks to my success. I've been able to budget, hire staff, and operate in a very efficient court. Thank you.
Thank you. Mr. Houlihan.
I'd like to thank the League of Women Voters for putting on this forum. It is the only forum that we have in this campaign, and I think it's a tremendous public service. I appreciate the voters and soon-to-be voters who are here in the audience and those that are going to watch us on television later. Thank you for your participation. The probate court may be your most intimate connection to government in your lives. It's there when you're having serious problems with the family or somebody has died. People arrive at probate court in crisis. At best, it helps families to move forward, but it provides structure and resolution to many of life's woes. I've been encouraged by the bipartisan support that I've received in my campaign. Trial experience is invaluable in handling some of the difficult cases that come through this court. The respect that I've received from those on the other side of cases of mine and of different political beliefs gave me the encouragement to run this race. I have been serving people for 25 years in Farmington Valley. They bring their problems, we try to resolve them by negotiation, by mediation, by litigation where necessary. It's important to have this broad perspective of what happens in the world. When the developer comes to probate court because they need to, they want to buy a piece of property, it's important that the probate court understand the development process behind it. If for no other reason, maybe one of the beneficiaries is facing foreclosure on his home and needs the sale proceeds. You need the broader perspective that I bring to this because I have been solving people's problems for a long time. I've also had the consumer side of it. I was a guardian for a mentally ill sister. My father-in-law lived with us for over 6 years in his 90s. And with those experiences, I bring all of that to the probate court. Thank you.
Thank you. Thank you both very much for your participation. I think this is the first time I've had a probate judge candidates night, and it's been quite informative. So thank you very much. And